Well, welcome everyone. I'm Jennifer Hill, and I'm very much pleased to welcome you on behalf of Monash Law School and on behalf of the Centre for Commercial Law and Regulatory Studies, or CLARS. Before we get underway, I'd like to acknowledge the traditional custodians of the land that I'm on today, the Wadawurrung people of the Kulin Nation, and I do pay my respects to elders past, present and emerging. So tonight's seminar is about risk and what new species of risk, what they bring about as problems for directors. And so last year, many of you would have attended some of the seminars that were given by a CLARS visitor. That was Roy Shapira from Reichman University in Israel. And Roy has got a new paper out with co-authors Asif Eckstein and Ariel Shillo that's entitled Board Overload. And in that paper, he looks at the expanding range of risks that directors have to be across and asks, is it really feasible that they can be across those, particularly, in an era where so many directors are independent directors. And they talk about, the danger of information fatigue. And so tonight's seminar, we're going to kind of split the atom there. And we're going to disentangle the risk on the one hand, and then what that particular type of new risk means for company directors and their responsibilities. And so our two speakers, we have Anton Moiseienko. He's going to discuss the massive expansion, really just this year, in terms of financial crime rules in Australia, things like anti-money laundering and counter-terrorist financing. And then our other speaker, Joan Loughrey, is going to talk about the implications of expanded monitoring and obligations for directors, with a focus on developments in the United Kingdom and what's happening there. So let me just tell you a little about the speakers. I've only just met Dr. Anton Moiseienko. He contacted me several months ago and said, I've got a new book. You didn't tell me the title of your new book at that time. It's a great title. He says it's a great title. You can't say that yourself, but I can say it's a great title. It's called Doing Business with Criminals. It's Cambridge University Press 2025. And it's about, corruption and targeted sanctions. And he's also co-edited 4 books on transnational crime and published in some of the world's leading journals. And I just learnt that he hails from Ukraine and did your master's degree at Cambridge. And he's now at Australian National University after spending several years in the UK working in this field. Now, Joan Loughrey, on the other hand, Joan I have known for many years. I can't even remember when we first met Joan. She is a visiting scholar at the Centre for Commercial Law and Regulatory Studies, and she is Professor of Corporate Law and former Dean of the Law School at Queen's University Belfast. And before that, she was the former Dean at University of Leeds. So I'm going to hand over first to Anton to talk to us about the range of new risks that directors in Australia are facing. And then Joan's going to come in. You're going to talk for about half an hour each, and then we're going to open it up for questions. I don't know if either of you would want to have questions as you're going along. Maybe we'll leave them till the end. So make sure you don't forget your questions. Over to you, Anton.
Good evening, everyone. Thank you so much, Jennifer, for accommodating my initial email outreach to you. Yes, it's delightful to be here, and thank you very much, everyone, for coming. Great to meet Joan as well and be part of this double act. And I would like to echo as well your acknowledgement of the traditional owners of the country where Melbourne sits. So I'm going to talk today about some of the global and Australian context for what is an ongoing and dramatic expansion in the regulation that many Australian businesses face, and that is anti-money laundering, counter-terrorist financing, and counter-proliferation financing regulation. as Jennifer mentioned, I've been at ANU for 5 years at the law school. And prior to that, I worked on financial crime matters in a British defence and security think tank called the Royal United Services Institute, looking at how this kind of regulation affects businesses in the UK and globally. And so it's almost a stunning natural experiment to see this regulation being now rolled out in Australia, but also what preceded the enactment of the relevant laws. So to give you a sense of the scale of what we're talking about, currently banks, casinos, and bullion dealers, as of a couple of months ago, were subject to AML CTF obligations in Australia, and their number was approximately 17,000 across the country. Now, as of the 31st of March this year, 2026, the array of regulated businesses has expanded to encompass real estate practices, legal firms, and accountants. And that will bring the number of regulated businesses in Australia in this particular domain of regulatory activity to approximately 90,000. So five-fold increase in the regulated population that AUSTRAC will now be vigorously overseeing. And what I would like to do in this presentation is to provide some comments on how we got here and what I think lies ahead, looking at the global context, some of the international push factors that led Australia to enact this regulation, but also some of the persistent doubts around what it means and whether it's likely to be effective. And of course, the issue of the burdens for directors and everyone else involved is an essential part of this equation, because burdens they will be and work will have to be done. So what is on the other side of the equation? What is the tangible societal benefit? A lot of commentators have been skeptical. So what is then this international context? Australia is a founding participant in the international regime that is overseen by the Financial Action Task Force, FATF, often described as the most powerful organization many people have never heard of. Now, this is a cliche that's been used in relation to many, many organizations, but the FATF may well be one that deserves the characterization. When it first met in 1989, it developed a global system of standards that were meant to help countries detect, prosecute, and seize drug-related money laundering. Over time, the ambit of the organization has expanded to all forms of predicate offenses, crime that generates criminal income, but also terrorist financing, and since 2012, the financing of proliferation of weapons of mass destruction. If you fall foul as a country of the FATF standards, you run the risk of being grey-listed, which is a reputational embarrassment and damaging for your economy because others will shun you, or in extreme cases, blacklisted, like Iran, North Korea, and Myanmar. Now, Australia is very, very far from being blacklisted or even grey-listed. But for a long time, Australia has had one foot in and one foot out of the FATF regime, in that it only expanded this regulation to banks and casinos and didn't address non-financial businesses that the FATF said were widely susceptible to money laundering and terrorist financing and could generate useful intelligence on those criminal activities. And that includes specifically the businesses that I've mentioned: lawyers, accountants, and real estate agents. So for a long time, Australia had been holding out, and the resistance crumbled in 2024 when the relevant amendments were enacted in a last-minute vote in the Senate, with one vote making the difference between the adoption and the failure of those reforms. They have now been adopted. Now, a number of bodies that represent the professions affected were critical of these reforms, and the Law Council of Australia is one of them. They argued that the expanded regulation will hurt the legal profession for various reasons, partly matters of principle. So you need to do customer due diligence on your clients and report them if they engage in suspicious activities, but partly for practical reasons. A lot of law practices are small businesses. Maybe a single solicitor operating in a rural Australian town. Now they have to face those obligations. And those concerns apply as well to real estate agents and accountants. So this is by no means a marginal critique of the reforms that were adopted. One of the leading academic experts on AML-CTF in Australia is Professor Jason Sharman, who's now in exile at the University of Cambridge. And so from Cambridge, he can make controversial statements about Australian AML-CTF reforms. And one of those controversial statements was to critique the expanded regulation and to say, look, it represents a triumph of hope over experience. There are all those other countries around the world that have it, including the UK, including EU member states. Have they fixed their money laundering problems? Well, no. If you look at the United Kingdom, which of course is a close comparator for many reasons, their National Crime Agency consistently estimates the amount of money laundered through the UK in hundreds of billions pounds a year, billions with a B. And when I did research for my book, I had the opportunity to interview some of the officers involved in that assessment. And I asked them, how did you come up with the figure? And they said, that's just the largest figure we could think of. We didn't know what it really is, but we wanted to imprint on the minds of policymakers that the problem is significant. So why then is there so much critique of this regime that has been expanding globally for 30 years and has now come to Australia? What are some of the challenges that it engenders? Well, let's go back to some of the key pillars of the regime that I've mentioned. If you are regulated, and to be clear, these obligations are coming into effect from the 1st of July this year. So the clock is ticking for all those 70,000 businesses that are about to find out what AML-CTF means. Now, what that means is you need to conduct customer due diligence. So you need to know not only the identity of your client, that's the bare, not even a minimum, that's the baseline, the starting point. You also need to know, well, what is that kind of transactional profile that you can expect? How much money do they have? What are their sources of income? What will be typical activity that you might expect to see, and what is something that will be anomalous and therefore reportable as suspicious? That leads me to the second pillar, which is the reporting of suspicious matters. The Australian term is suspicious matter reporting. So you need to file those reports to AUSTRAC. And then on top of that is a range of requirements relating to developing your AML-CTF program, keeping records, etc., etc. So potentially a considerable burden, but also let's think about the incentives that the regime engenders. If you might be penalized by the regulator for missing suspicious activity that you should have reported, what are you going to do as a prudent business? You will over-report. So if something is potentially, maybe, could be suspicious, you will file a suspicious matter report. But that's not cost-free, because that costs staff money. And that is still a burden on your business. So the other thing that you will do if you're a prudent business is you will do this, which means that you will drop the categories of customers that cause you to file those suspicious matter reports. And if an individual customer puts you in that position where you have to file off an SMR to AUSTRAC, you might do it once, you might do it twice. It's incredibly rare for businesses to do it 3 times. Again, the interviews that I conducted across Australia, Europe, the UK, and the US suggested that in various jurisdictions, businesses invariably adopt informal 3 strikes and you're out rules. Now, who is affected by those rules? It might be that they're genuine criminals, in which case you have to think about the displacement effect, because they will be dropped by the responsible business that reports them, and they will go elsewhere. And that elsewhere may look different. It might be a less conscientious business. It might be an unregulated sector, for example, international trade. You can use that to move money, or it can be the cash economy. De-risking might also affect, and has been affecting around the world, people who don't have the right documents or who face One might say prejudice. One might say that they come from high-risk countries because of their passport. So, for example, you're a citizen of a grey-listed or blacklisted jurisdiction by the FATF. You haven't done anything wrong yourself, but good luck getting access to those banking services if businesses act on the incentives that they are given. So those are some examples of the unintended consequences that follow from the installment of this regime: over-reporting, de-risking, and displacement effect. One term that you might often come across is tick box compliance, where businesses do what's cheapest and easiest for them to superficially comply with the letter of AML/CTF regulations. And then you might ask, well, what else are they meant to do? They are private businesses that comply with what obligations they're under the applicable AML/CTF regulation. What is the problem? But of course, as we've seen with those unintended consequences, the problem is that the regime might not contribute societal value or law enforcement value that's commensurate with the inputs into the regime in terms of the time and money. So what I did in the project that formed the basis for the book is to try and do a historical deep dive to ask, well, how did we end up with this regime that is so universally critiqued by pretty much everyone who's involved in its operation, from policymakers to private sector businesses to law enforcement agencies? And what could we do better? So what are the features of this regime that are immutable, that we can't really change? They have to be there. For example, customer due diligence. It's very difficult to imagine any anti-financial crime regime where you don't know who your customer is. That doesn't work. And what are the features that are contingent and could be fixed? For example, suspicious matter reporting. Maybe that's just not the right way of feeding information from the regulated businesses to law enforcement agencies. And that was a fascinating, I think, exploration, in the sense that I've learned a lot from just looking back at the evolution of the regime from the 1970s onward. And what I found is that fundamentally, it pursues a range of different objectives that are sometimes in conflict with each other. So there's a whole raft of rules that have emerged in order to keep criminals out of the legitimate economy. This is what I describe as the exclusion objective. For example, criminalizing complicity in money laundering, making it a crime to provide services that are designed to help someone retain the proceeds of their crime. But there's also a swathe of rules that are aimed at financial surveillance of suspicious activity. So suspicious matter reporting, other obligations for regulated businesses to feed information to law enforcement agencies. And those two things can be in contrast. I still remember one of the first financial crime roundtables that I went to in my previous job, where a very senior former law enforcement officer who worked in banking compliance shocked, and he liked to do it in every discussion that he went to, shocked everyone else present by saying, I want criminals to do business with my bank because then I can surveil them and I can report them to my law enforcement contacts. Now, that's one way of approaching the dilemma that this contradiction engenders. Others would take a much more risk-averse approach, perhaps because they didn't have those established law enforcement contacts. But there are other tensions as well. What about the tension between financial privacy and this idea that certain businesses, including our lawyers, accountants, and real estate agents, report on us to law enforcement agencies? There is a tension there, and how it is navigated varies subtly, but importantly, country by country. And of course, there is the tension between the presumption of innocence, understood as a broad societal value, and the whole idea of denying access to services to someone because they might be, there is a suspicion that they're involved in crime. Those two things do not necessarily fit easily. And so what we have is a regime that pursues a number of different objectives, is defined by trade-offs. And what is unique about it is not so much that there are many different objectives that inform a particular area of law. That's commonplace in all legal systems and across domains of regulation. It's that the ultimate striking of the balance is delegated to private sector businesses. They need to decide If we have Iranian customers, Iran is blacklisted by the FATF. What do? Do we just say, no, thank you, go somewhere else? What if we file a suspicious activity report on someone 4 or 5 or 6 times? Do we keep them on? Do we try to pick up the phone and get informal advice from Austrac? What do we do? Those are all decisions that are delegated to the private sector. The way that they are addressed by the private sector is by doing what's cheapest and easiest. And that's not always aligned, and very often clearly not aligned, with societal and law enforcement objectives. And this is why we end up with this feeling of the outputs of the regime not being equal or even commensurate to the inputs in terms of the cost, the time, and the effort involved. And so what I looked at in the book is the various ways of aligning the compliance practices of the private sector with law enforcement objectives. And so the conclusion that I ended up with is the extension of AML-CTF regulation to new sectors as mandated by the FATF is just the first step in this journey. The second step is building public-private partnerships to align compliance practices with what law enforcement needs, creating ways of feeding information to law enforcement agencies that are frankly better than just sending in whatever you think is suspicious in order to avoid regulatory penalties, but also in some cases coming up with bespoke law enforcement powers. Australia is an interesting example. So one of the new powers under the reforms is something known as keep open notices, where law enforcement agencies can go to a regulated business and say, even if you would otherwise close this account, don't do that. We need you to keep providing services to this person for law enforcement reasons. Please keep doing that. So there's a spectrum of potential responses to that. And as I thought about them, I was reminded of a comment that my colleague used to make, where he would be critical of a lot of AML technology that vendors often offer in this space, saying that it tends to make stupid cheap. And so the question then is, how do we move beyond making stupid cheap and just engaging in practices that produce intelligence that, frankly, no one has the capacity to read, because if you're a law enforcement agency, you're bombarded by SMRs. And I think part of the answer is those various practices that bring private sector efforts into this greater alignment with law enforcement objectives. I'll stop here. I hope that sets out some of the key dilemmas in the policy space that Australia will have to consider. And I suppose one way of looking at ensuring that the burdens come with the appropriate benefits on the other side of the equation. Thanks very much.
Okay, now I've got to grapple with the technology, so just give me a minute. I can't tell you how proud I am of myself to have done that. All right, so I'm going to be talking about something a little different, but there are definite connections as I was listening, and in particular to the idea of what's the point of some of the regulation that has come in. All right, so that's where I live. That's Queen's University Belfast. If you're ever over, you're very welcome to come and have a look around. It's a lovely campus. I'm going to be talking about the expansion and regulatory responsibilities for the monitoring board in the UK. I could call this a postcard from the UK, really, because it's about the position in relation to the director's duty of care in the UK, which I think is quite different to the Australian position. And I'm going to be contextualising it in relation to the expansion of societal expectations of boards and of companies in relation to taking decisions and actions that have societal impacts. For example, it's really come up the agenda in relation to discussion of the climate crisis, but it also arises in relation to human rights. And this has brought renewed focus on directors' duties in the UK in the light of a famous decision called Client Earth and Shell, where activist shareholders brought in action against Shell PLC for not aligning their policies with achieving net zero. It was unsuccessful. And actually, a lot of people have written about that, and I'm not going to talk a lot about it tonight, but that's the context of the discussion. And what I'm going to be focusing on is the responsibility of the law and the courts to respond to these societal expectations and what I think is the shortfall in the current law in the UK. And we have seen these discussions in relation to corporate purpose. We've seen it in relation to ESG, but today I'm going to be talking about directors' duties, and in particular the director's duty of care, which in contrast to Australia is a much neglected duty in the UK. So I'm going to be talking about two functions of the board. They have a couple, but two main functions. One is their managerial authority. So in the UK, boards are the central management authority of the company. The UK model articles of association provide that directors are responsible for the management of the company's business. But of course, in boards of any size, they delegate these duties out. They're not generally involved in the operational decisions of the company, but they are involved in very major key strategic decisions, such as, for example, a decision to launch a takeover bid. But most operational decisions are going to be delegated. And of course, that then gives rise to the other critical aspect of the board's role, which is the monitoring duty. Now, monitoring is important in two respects. First of all, it's about monitoring those delegated functions and making sure they're performed appropriately and to take action if they're not. And quite often when directors are found in breach of their duty, because it's a duty of care that is called into play when directors fail in their monitoring role. Quite often, when directors have been found to have breached their monitoring rule, their duty of care in relation to monitoring, it coincides with failing to monitor or failing to pick up on agency costs. So the corrupt CEO, the person who's taking money out of the company. So there, the monitoring rule very closely aligns with the corporate governance rule of monitoring for agency problems. But the second monitoring rule is more aligned to the board's operational role. And that's where it's required to ensure that the directors themselves are properly informed when they make operational strategic decisions, such as a takeover bid, or that they become alerted to the fact that they need to take a decision such that, for example, the company is getting into financial difficulty and they have to decide whether to allow the company to continue to trade or in the UK fall foul of what's called the wrongful trading rules. Now, these two monitoring functions overlap, but they do tend to get conflated in the case law. But the monitoring obligation is really important in large companies, obviously, because directors are so often distanced from key decisions that result in harm to company or harm to the shareholders or harm to third parties, and whether that's deliberate or accidental, there's a debate. So the expectations placed by the law on directors to monitor is the primary means by which directors' duties can be utilised to influence directors to have regard to and to mitigate societal harm. So it's really important. And the monitoring rule has been described as the most critical aspect of the director's duty of care. So what have the UK courts said about the monitoring rule? Well, the first thing up is that we don't have that many cases in the UK on the duty of care. I'll be talking about some of them later. You know, for 66 years, we didn't have very many. Then 3 came along at once, and then another 21 years, and then 3 came along at once. So that's kind of, we have ones that are tinker about, but in terms of important cases, we don't tend to have a huge number. But going through what they've said, in terms of monitoring others, we have dicta that say non-executive directors have to monitor the performance of executives, hardly a surprise, but there is no requirement to overrule specialist directors, say specialist directors such as finance directors. Again, where a director has a record and reputation for outstanding skill and experience in the company's business activities, other directors are entitled to accord a high degree of deference and trust to his views as to what's in the company's interest. That was the Madoff case. That was the UK Madoff decision, Madoff running the Ponzi scheme. So even though, I think the directors got off slightly lightly there, but then he had fooled everybody. But in that case, the managing director, money was going out of the company to pay for research that the managing director didn't think was of any use at all. Indeed, it wasn't of any use. It was just a way of extracting money from the company. But nevertheless, he wasn't in breach of his duty because he was entitled to rely on Madoff's assurance that it was just useful, even though he thought that it wasn't. So, but they must respond to red flags. So where there are reported problems to them, they must take steps to address them. As for keeping informed, the courts have said a bit about systems. That the directors must pay diligent attention to corporate systems, whether they're working efficiently, mainly focusing on financial information, mainly being articulated in the context of small companies, because that's where most of our litigation is. Sometimes the courts can be quite prescriptive. So in IT Protect Limited and PI, the court said you should be looking at financial information once a week. But these are directors who are not very skilled. These are small companies. There is a Court of Appeal decision which said that directors should acquire the necessary knowledge and understanding of the company's operations and ensure that it is compliant with issues as wide-ranging as trading standards, health and safety, and taxation. And before everyone panics, this was a case where a director was doing all the managerial stuff. It was a really small company. There was only a couple of people who could ensure that the company complied with these things. There was no delegation going on. Rebearings, how active does the director's duty of monitoring and oversight have to be? That's really a moot question. There is this dicta in rebearing saying that it's rare for directors to escape responsibility on the basis they didn't know or were not told of systems and individual failings where there have been serious continuing failures on the part of individuals, which suggests that the directors must have some sort of reporting mechanism in place so that they learn about these the failures, because otherwise how will they know? But that's really the only thing I've been able to track down on this point. And in the case that I am going to be talking about quite a bit, which is Sharp and Blank, which came along in 2019, just before COVID, so I didn't pay too much attention to it, although I did read it at the time. Here, Sir Alistair Norris, and this is a really important first instance decision. He said, in the absence of grounds for concern, a director is entitled to trust people to perform their duties without suspicion. And he took us right back on that aspect to City Equitable Fire Assurance and Dovey and Corey, which doesn't suggest the duty of active oversight. But if you combine it with the comment in Bearings, you can imagine a counsel in a case trying to run an argument on that there is, in fact, a duty of active oversight if a case ever got to court, which I don't think is, I think is becoming less likely. Now, turning to regulation, there has been a huge amount of discussion in relation to the changes to the UK Corporate Governance Code, Principle O and Provision 29. Together, these stipulate that boards are responsible for establishing, maintaining and monitoring effective risk management and internal control frameworks. And the monitoring and review should cover all material controls, and these include not just financial, but also operational reporting and compliance rules. So that emphasis on compliance could have a direct public benefit because it's clearly in the public interest for companies to comply with the law, and it could have implications for the director's duty of care. However, there is very little case law in the UK, next to none. There's one case, and it's in a small company, suggesting that directors will be liable for failing to for a breach of their duty of care for failing to ensure that their companies comply with the law. Will these changes to the UK Code of Conduct, Corporate Governance Code, will they change this? I am doubtful, again, for reasons that I will explain. So this really links into your point, because there is a huge amount of literature and work going on to make sure that boards are compliant with Provision 29 when it comes in. People are making it's an absolute industry, but is it going to really make any difference for the costs that are involved in terms of, the amount of preparation that's going on for this? And that is a moot question. And from 2027, boards are going to be required to make a declaration of the effectiveness of these controls. And what impact that will have, it's obviously too early to say, but I can say it has already increased the regulatory burden. So, and then we have this, which is the Economic Crime and Corporate Transparency Act, which introduces a new failure to prevent offence. We already have one in the Bribery Act, where a person who's associated with the company commits a fraud and intending to benefit the company, then the company commits an offence unless, and here's where the directors come in, unless it has reasonable systems in place to prevent the fraud, or it could not reasonably be expected to have systems in place. And the UK government's guidance on this says that responsibility sits with the board. Ultimate responsibility sits with the board. Now, they're going to delegate that responsibility out, and so they're going to have to monitor it. So here we come to the directors' monitoring obligations again. How is this regulation meant to work? So regulation can work in two ways. First of all, it can just, directors do what they're told by the regulation, and then everything is great, and we achieve our regulatory objectives. But it's also been argued that directors face considerable exposure to personal liabilities for failures in risk management and oversight and control as a result of increasing this regulatory requirements, such as the ones I've outlined. And this is because the increased granularity of the regulation and other self-regulatory initiatives will flesh out what constitutes what is reasonable director conduct under our section 174, which is our director's duty of care, skill and diligence. And one of our leading academics, Paul Davis, has suggested that the courts may take into account the stipulations in the UK Corporate Governance Code in assessing whether directors have acted reasonably. And the provisions could encourage judges to more readily recognise active oversight duties. Now, there are no cases so far where the courts have found directors liable for breach of any duties because they failed to comply with the UK Corporate Governance Code. And I'd actually be very surprised if that happened, because the UK Corporate Governance Code is comply or explain. It is not compulsory. And it would be anomalous to start enforcing it through the duty of care. It also operates as a very high level of specificity. So I don't think it has the granularity. I just don't think the courts are going to enforce the UK Corporate Governance Code. I can't, but I could be wrong. So I want to now talk about what I see the big problem is with the duty of care and with the director's duty of monitoring in the UK. And that is, I think it's pretty much becoming unenforceable. And it all does turn on the objective standard in our section 174, which are statutory duty of directors' care, skill and diligence. So before section 174 came in the Companies Act 2006, we thought that the law had become more demanding of directors. We thought that directors' duty of care was becoming more stringent. And we thought that it moved away from the historic 19th century cases and the Re-City Equitable Fire Assurance Company 1925 decision, which were thought to have fairly low requirements of directors. And Parkinson, writing in 1993, now Parkinson understood these cases very well, because there's been a whole debate about whether Re-City Equitable Fire Assurance was properly understood. But Parkinson understood these cases perfectly well. And he said that it's possible only to speculate now in 1993 whether the approach of Justice Romer in these cases and of Lord Hatherley and Overend and Gurney and Gibb remain good law. Then when section 174 came in, we have that statements that the standard of care, skill and diligence in 174 brought what was required of directors into line with what was required generally in other areas of social life by the law of negligence. And we have similar statements in a leading textbook, the most recent edition of the leading textbook for students in the UK, Dignam and Loughrey. So the law was perceived to have changed since Re-City Equitable Fire Assurance, since Overend and Gurney and Gibb. So what does section 174 actually say? It has a standard of reasonableness. A director of a company must exercise reasonable care, skill and diligence, meaning the care, skill and diligence that would be exercised, and it's a mouthful, a reasonably diligent person with the general knowledge, skill and experience that may be reasonably expected of the person carry out. So there's a lot of reasonably in there. There's a lot of reasonably in there. And that's an objective standard. That is the minimum standard that a director must meet. They must meet this reasonable standard. This second part of it is a subjective standard. It raises the expectations of directors. And then we have sharp and blank. Now, sharp and blank is a 400-page judgment. And in it arose out of the financial crisis. The shareholders of Lloyds Bank sued the directors of Lloyds for breach of duty of care they said that the directors owed to them in relation to statements made in a circular to the shareholders recommending the takeover of HBOS. The shareholder said that the circular did not contain full information. It was not, and that the directors should not have recommended the takeover. Now, the defendants conceded that the directors owed a common law duty of care to take reasonable care and skill in the statements in the circular. And Lord Justice Norris said that common law duty of care, the content of that common law duty of care, was basically modelled on the Section 174 duty. So the duty that the directors owed to the company and the duty that the directors owed to the shareholders was one and the same thing. They had the same principles. And so he talks in great detail about Section 174, also Section 172, another duty that I won't talk about. It has now become one of the one of the cited cases, one of the main cited cases for the director's duty of care in the cases and in the textbooks. What did he say about the standard? And forgive me, there is a reason that this is so long. I want to come back to it. What he said was the directors had to undertake an analysis of the position and to make a prediction about the likely consequences in the long term of any decision they might take in relation to the takeover. This involves a process of valuation and the exercise of judgment. And here we have Overend and Gurney and Gibb just flashing up. Lord Hatherley and Overend, Gurney and Gibb in 1871 said that the court had to ask, in deciding whether directors negligent, were the directors cognizant of circumstances of such a character, so plain, so manifest, so simple appreciation, that no men with any ordinary degree of prudence acting on their own behalf would have entered into such a transaction. And this is the thing, we've had a sort of common law business judgment rule, but what Sir Alistair Norris went on to say was, this decision may today be taken as establishing the irreducible objective standard of the reasonable ordinary businessman. That seems to be saying, saying the objective standard in Section 174 is not reasonableness, it is irrationality. I was surprised when I saw this. But the one thing, and then I thought, well, he's talking about judgment. He's definitely talking about judgment in that quote. So is he just applying that to the concept of, is this just a business judgment rule? You're challenging the director's judgment and the courts won't refute that. He also used a range of reasonable decisions test, bringing in Brazilian rubber plantations, which we also thought we had departed from, in testing whether directors be negligent. The question not simply what the court thinks would be reasonable. It's not the court's views that matter. It's what the evidence establishes where the course is open to reasonably competent directors. So Klein, Earth and Shell really drove attention to this because it was such a high profile case and it really flags up. I'm not going to talk about, there's plenty of people who talk about Klein Earth, but what it demonstrated was the importance of this, the application of this standard when it comes to the public facing aspects of a director's role. The claim was unsuccessful and it is going to be very difficult to challenge directors on this basis now for breach of their duty of care and skill. It's also doctrinally incoherent. It doesn't line up with previous case law, which I won't go through. It doesn't line up with Rita Jan. It doesn't line up with the provision in section 1157, which is an exculpatory provision. So I'm thinking, well, how do we reconcile this? Well, Kershaw wrote a book in 2018 where he said that Section 174 does not apply to the review of the quality of the substance of directors' decisions. They don't fall within Section 174. They're non-justiciable. You can't challenge directors' decisions. You can only challenge them on process. And he actually criticised an earlier decision of Sir Alistair Norris, Robertson Froelich, where Sir Alistair Norris had reviewed the quality of directors' decisions on the basis of irrationality. So Kershaw's lost the argument on that basis, certainly at the minute, because Sir Alistair Norris then subsequently in Sharp and Blank, which everyone's citing, says no, decisions do fall within Section 174, but it's irrationality. Well, how does that work? So is it that irrationality applies to quality, to the substance of director's decision? Does it only apply to commercial judgments? And then reasonableness applies to process or to failures to act or to decisions that are not commercial judgments? Maybe, but there's no distinction drawn by the courts. There's none in Section 174, and we don't have a business judgment rule to approach this in any kind of structured way. So what's happening? Well, Brighton Chapel, this is 700 pages long, and I tried not to sound resentful about that when I had to read it. I've read it, so you don't have to. Now, this was the collapse of a very high-profile collapse of a high street name, British Home Stores, and the directors were ordered to pay £110 million to creditors for breach of their duty of Section 174, 172, and wrongful trading. So you say, well, hey, you know, the duties have some bite here. They're not toothless, despite this irrationality standard. But actually, although it was a very high-profile decision, it fitted the kinds of things where the courts will intervene. The company became insolvent. It was a private company. There were a small number of directors. It was concentrated ownership. There was gross negligence. To give you an idea of the type of negligence that was involved, the director who was the general counsel of the company and took on the role for this high street, very high profile company, had been a criminal defence barrister until he took over as the general counsel and didn't know anything about corporate law, right? So he got things, the whole thing was a circus, quite frankly, okay? But when it comes to the law, what do we find? Well, we do find Justice Leach looking at the process that directors were taking to reach their decisions, looking at it very closely. He talked about the process which the court would attach to professional advice, and you can see the sort of factors he took into account. But he then went on to say that whatever systems the directors have put in place, whether to inform themselves about a decision, whether to monitor, the court must still be satisfied that the individual decision, which is the subject matter of the claim, was one which no reasonable director would have reached. So unless the director fails to make a decision, as long as the director makes a decision, then no matter how defective the process is, as long as the decision could not be described as irrational, it looks like they will escape liability under the duty of care. And I just want to critique this, actually, and talk about this. So, and I'm going to talk about it from the point of view of the public who are impacted by directors' decisions, because company law obviously looks is quite internal looking, but we know that the big discussions these days are about this societal impacts of corporate behaviour, environmental crisis, and down there below. Those are the mothers who've lost their children as a result of social media activity. We know there was that case in the US. It was not a foregone conclusion that they were going to win against the companies, the social media companies, in terms of the addiction mechanism, in terms of knowing that children were on that young. It was uncertain, and my point there is we can't rely on tort. Yes, they won, but it was not for sure that they were going to win. And I want to talk about BT 2000, the Sequana case, which some of you might be aware of. And I want to tell Lord Hodge's story. He said, suppose a company has been unsuccessful and shareholders' capital has been lost, and directors knew the formal insolvency is more likely than not, and there's a prospect of avoiding insolvency with a particularly risky transaction, but the company's assets would be lost if the gamble were to fail, and the shareholders have nothing to lose as the last roll of the die. He said, to my mind, the law would be open to justifiable criticism if it were to provide no remedy in respect of the interested creditors where such a course of action was proposed without proper consideration. He felt uncomfortable that a decision that exposed creditors to very high risks and shareholders to none could proceed without any consideration of their interests. Now, in Sequana, the court got around that by recognising a duty to take account of creditors' interests, but that is not open in relation to other stakeholders. It is absolutely embedded in UK company law that shareholder interests come first, and insofar as they take account of other interests, it's only insofar as it advances shareholder interests. In Sequana, Lady Arden said, well, it could be a breach of the duty of care. Directors would be breaching their duty of care if they proceeded in this situation. And Lord Hodge doubted this, and in the context of the illustration he provided, he was correct to do so, since in that instance, the company had shareholders had nothing to lose and everything to gain from the risk to be taken. And if the focus is on shareholder interests, which it is, then it was a rational and indeed possibly reasonable decision to take. But it's otherwise where the risks taken harm third parties, actually result in harm to third parties. Such decisions can also cause harm to the company as a result of it being sued in tort or suffering reputational damage. And it could, in theory, leave directors vulnerable to being sued for breach of their duty of care to the company. Although, as I've said, the case law in that area is very underdeveloped in the UK. In this scenario, and I'll finish shortly, in this scenario, a standard of unreasonableness or irrationality adjusts the risks to third parties More specifically, while it's an embedded feature of UK company law, shareholder primacy is an embedded feature, that third parties bear the costs of corporate conduct without necessarily any concomitant benefit. The choice of an irrationality standard by the courts to review directors' decisions increases the consequences of these risks occurring. In other words, it increases the risks of third parties being exposed to conduct that from their perspective, but not the company's, constitutes irrational risk-taking, because their interest don't count. This can occur either because directors themselves take these decisions or they fail to monitor adequately. So in other words, an irrationality standard increases the level of risk shifting the law will tolerate. So even if a tortious remedy is possible, it's unclear why tolerating this degree of risk is okay in relation to third parties, but not in relation to was indefensible in the context of creditors, but not in the context of third parties. And Kershaw has argued that the duty of care is the portal for the imposition of objective communal expectations and control in directors. And when the law gets too far out of sync with societal expectations, then it needs to change, or there needs to be a plausible reason for the current position. So is there a position? Well, the current position relies on the idea of directors as scared mice, that they're risk averse, that they won't take up their positions as directors if there's increased liability. There's no evidence for this. I'd be very interested in this evidence. There's plenty of evidence going against it. And what I would say is that people who are seeking to argue for a position where directors, any particular group of people are insulated in a way that others are not, then it's up to those people bringing that argument to provide the evidence and to justify it, which does not happen. What the evidence suggests that directors are more like is overconfident. You know, these are people where the law is somewhere out there and they're concentrating on their business decisions. The problem is more likely to be overconfident CEOs. And I do refute a number of the arguments in that chapter. And that's it. So I will finish there. And thank you very much.
So Anton and Joan, thank you so much. That was fascinating.